Welcome, everyone. This is the 2024 Changes in the Law presentation by the Carpenter Law Firm. My name is Scott Carpenter, and it would seem that things should calm down over the years, but the legislature every year seems to churn out new changes. And you'd think, well, last year everything was changed, so why not keep things stable? But that is not the case. So in 2024, there were 9 bills that I'm going to talk about. A bill becomes a law, and so I want to go through those here today. And I endeavor to keep these seminars to 59 minutes. We'll see how I do today. I'm going to try, but I'm going to go through these one at a time. So I'm going to start with what the legislature did. Well, they adjourned on June 15th of this year. And 9 bills, as I said. There's one from last year I want to discuss briefly, parking. It's in the statute now. Bills become law, and they were effective 90 days after the legislature adjourns. And so I want to talk about one that has a June 30th, 2025 deadline. In 2023, this seemed like a long way off, but now it is less than 12 months away. I'm going to spend a minute at the end on a federal statute, the Corporate Transparency Act. There are some people who think this went away or that there was a court case in Alabama. That's true, there was a court case in Alabama. This did not go away. We have a few months left to comply with the Corporate Transparency Act, and hope is not a strategy here. We have to comply with it. It did not go away. So I'm going to spend a few minutes on this toward the end. And all of the 9 bills that I'm going to talk about have an effective date of September 14th, 2024. This is coming up in 2 months, roughly from today. It's a Saturday. The Saturday, of course, has nothing to do with it. September 14th, coming right up. So the first one is House Bill 2141. This is a condominium only statute. We could call it the hard surface flooring statute for second floors and above. The statute says the following. Copied and pasted here. I want to go through it quickly. The association shall not prohibit, can't stop a unit owner from improving or altering the interior of the unit in a manner that may disturb adjacent unit occupants if the unit owner purchases and installs at the unit owner's own expense any reasonably necessary improved materials, accessories, or other adjustments that may eliminate or minimize the potential disturbance. And then there's a final sentence, which we'll get to in a minute. The association shall not prohibit a unit owner from using any manner of decoration on the interior of the unit. So let's go back and look at these sentences or these phrases in red. The unit owner may disturb adjacent unit owners. The legislature has said, hey, if you want to disturb the adjacent unit owners, you can. You now have permission to disturb the adjacent unit owners. Now, I think of this as a hardwood flooring issue, and it certainly is. But it also could be next door neighbors. You can disturb your neighbors if you want to. Now, this is a constituent-driven bill. An owner of a condo unit went to his or her legislator and said, you're not going to believe what my condo is doing to me. I can't have the hard surface flooring that I want to, tile, wood, whatever it might have been. But the constituent tells a story. And you're not going to believe what my condo is doing to me. There ought to be a law. And so we end up with bills like House Bill 2141, effective September 14th. So now the condominium is in the middle of a problem. Owners are now permitted by law to disturb adjacent unit occupants. And the owner only must, at the owner's expense, take action as reasonably necessary through improved materials, accessories, or other adjustments to eliminate or minimize the potential disturbance. Now, I think this bill might end up being one of the legacies of the 2024 legislative session. Because now we're in the world of, we have to allow owners to disturb adjacent unit occupants. And who decides the reasonably necessary improved materials, accessories, or other adjustments? Now, the unit owner will likely say, I'm the one doing the disturbance. I get to decide the reasonably necessary improved materials, accessories, or other adjustments. But the person who's disturbed might say, no, I want to be protected by the association. Or the person who's disturbed might say, no, I want to be the one to decide what's reasonably necessary to protect me. I'm the one who's being disturbed. We don't know yet. I mean, this is all a big mess. And so the challenge for condominiums will be to dust off the modifications policy. Many high-rise condominiums have hardwood flooring policies, and those are going to have to be revisited in light of House Bill 2141, because many of those policies have a minimal disturbance standard. But now we have this may disturb standard, or a zero disturbance standard in those existing policies. And now the statute says that the unit owner may disturb adjacent unit occupants, which could be side to side, it could be top to bottom. Or now the statute says that the goal is to eliminate or minimize the potential disturbance. Can an association say, no, the goal is complete elimination of the potential disturbance? The unit owner might say, I just want to minimize the potential disturbance. The statute says eliminate or minimize, and the homeowner says, I'm going to modify the interior of my unit. I simply am going to work to minimize the potential disturbance. And the HOA standard is no, eliminate the potential disturbance. These words are confusing, as you can see in red, and the third line up from the bottom, the legislature has the word or there. Could the association, these are somewhat rhetorical questions that I struggle with as a lawyer. Can the association say, well, our goal is to eliminate the potential disturbance, and the homeowners say, no, my goal is to minimize the potential disturbance? The legislature has enacted a statute that is troubling, because the association could adopt a policy that says our goal with interior modifications is to eliminate the potential disturbance, yet an owner could say, no, my standard is to minimize. So finally, if we look at this, we've got our problems and challenges. The disturbance is an assumption and a permissible given in the statute. The legislature has said, let's start from the given, the assumption that there will be a disturbance. That's a challenge for the association. The homeowner is going to modify the interior of their unit, and the modification will be a disturbance. That's a challenge for the association. And then we've got this challenge of who decides the reasonably necessary improved materials, accessories, and other adjustments to eliminate or minimize the potential disturbance. And as I just said, which standard is going to be used? Are we eliminating the potential disturbance, or are we minimizing the potential disturbance? The legislature has really messed this up by giving us both standards, the standard of eliminating the potential disturbance and the standard of minimizing the potential disturbance. And then the final piece of this, I'll go back here, that final sentence, the association shall not prohibit a unit owner from using any manner of decoration on the interior of the unit. The challenge here is that interior decorations may end up being offensive. And the association is probably not in the make sure the world is not offensive business. But we do have these challenges from time to time that CC&R provisions say no offensive activities, no illegal activities, things like that. But it is possible to imagine a world where someone would place an interior decoration in a window of a condominium that would be offensive. Now, we tend to use extreme examples to make a point sometimes as lawyers. An extreme example would be a anti-Semitic symbol, a Civil War era symbol, a racist symbol in an interior window that would be in the order of an interior decoration that would be offensive, and people in the community would be offended, expect the association to do something and to enforce a CC&R provision against an offensive activity. Yet the statute would say that's the owner's prerogative from using any manner of decoration on the interior of the unit. And that is something that could end up being offensive. So we may need to revisit our flooring regulations in what I'm calling a stacked condominium. Stacked being a term used in some places in the country for one unit on top of the other, because although, as I pointed out today, the statute, the House Bill 2141, does not use the term hardwood flooring, the way it's going to play out most likely is the disturbance will be regarding hardwood flooring and top to bottom noise in units that are on top of each other, whether high rise or not. Could be two-story condos. Let's talk about House Bill 2648. This is the assessment lien bill. It may end up being the one that people talk about the most, at least in 2024. But as I said, the hardwood flooring bill may end up being the one that we end up dealing with more, and I'm not sure about that, but it's just a prediction. So there's some significant changes to liens and collections. In a way, these changes may be an attempt to be a solution to a different problem. I'm not sure what the problem is. I'm not sure that the solution is, but the statutory lien. Now remember, there are let's remind ourselves what a lien is. A lien is a right. It's a conceptual thing. It's the right to take someone's property if they default on an obligation. If the property is collateral for an obligation to pay a debt, that's a lien if you have the right to take the property. If you go buy a new F-150 from Ford and you borrow the money from Ford to buy it, the moment you drive it off the property, they have a lien on the truck. They have the right to take it if you default on the obligation to make the payments. That's a lien. It's the right to take the property if there's a default on the obligation to make the payments. The lien is conceptual. It's an abstraction. It's the right to take the property if there's a default on the obligation to make the payments. So the association has a lien on the property if there's a default on the obligation to make the payments. What are the payments? The payments are the assessments. That obligation, that lien right, exists under the CC&Rs. That's a contractual lien. In Arizona, we also have a statutory lien under the Condominium Act and the Planned Community Statutes. In a way, we don't need the statutory lien, though, because we have a contractual lien. Just like Ford Credit, that's a contractual lien. Under the law, we can enter into a contract. I can say, hey, I want to borrow $10,000 from you, and I'll give you a lien on my Harley motorcycle. I don't have a Harley motorcycle, but if I did, I could say, hey, I want to borrow $10,000 from you, and if I don't pay you, you can take my Harley from me. That's a contractual lien. So we have the statutory lien, which is redundant in addition to the contractual lien. So the statutory lien now includes assessments, charges for late payment of assessments, late charges, if authorized in the declaration, no problem, that's good. Reasonable collection fees and costs incurred or applied by the association, that's good. And reasonable attorney's fees and costs that are incurred with respect to those assessments if the attorney fees and costs are awarded by a court. Now, the legislature here is trying to make life difficult for lawyers. No problem. Everybody hates the lawyers. We can handle it. But essentially, what they're doing here is saying, if a lawyer is pursuing an owner in a lawsuit or in a foreclosure, and the owner sells the home while the lawsuit is pending, then the attorney's fees are not going to be collected by the title company, because the attorney's fees are not part of the statutory lien, because title companies pay the amount secured by the lien at the closing. That is what title companies do. They clear liens and encumbrances. So only if the fees are awarded by a court. So moving forward, there's also another requirement, and this is a good thing. No beef from the lawyers. The board of directors must exercise reasonable efforts to communicate with the unit owner and offer a reasonable payment plan before filing a foreclosure action. That's lawsuit. Action means lawsuit. I think we're doing that. The board is exercising reasonable efforts to communicate with the owner and offer a reasonable payment plan before filing a foreclosure lawsuit. Nobody's arguing about that. Those are all good things. So let's remind ourselves what's happening with title companies. Title companies work for buyers and sellers to clear liens and encumbrances. Buyers want clear title. That's what's really going on. Who are the parties to the transaction with a title company? A title company is engaged by a buyer and a seller to facilitate a transaction. And the title company is engaged to be a middle person between the buyer and the seller, move money around, pay off the seller's lender. That's helpful to the seller. Their mortgage company is paid off. That helps the seller. But from a buyer's standpoint, the buyer is looking for clear title. They want to buy the property without any liens and encumbrances. They want to make sure that when they purchase the property, there isn't going to be a lien holder that's going to say, hey, you may have thought you were buying clear title, that there's actually a lien on the property from somebody that you had nothing to do with. That's fair. And so when the buyer buys the property, they want to make sure it's clean, that there's nobody that's going to make a claim on it. And so buyers want that clear title. And one thing we know about title companies, when they receive a payoff from all of the lien holders, whether it's the mortgage company or the HOA, any other lien holder that might have a claim on the property, title companies will not adjudicate the lien legitimacy. When the seller's mortgage company says the payoff is, let's make up a number, $395,000, the title company is not going to adjudicate or figure out or arbitrate or in any other way decide if that $395,000 is the correct number or not. They're not equipped for it. They have no way to decide or determine if that $395,000 is the correct payoff of the seller's mortgage number or not. They simply have nothing to do other than to pay it. So when the buyer puts, let's make up a number, $425,000 of cash into the transaction, usually from the buyer's lender, the buyer's own mortgage company that puts the money into the transaction. The title company puts $395,000 to pay off the seller's mortgage company. What are they going to pay? The $395,000, because that's what the seller's mortgage company said was the payoff. The title company is not going to decide if $395,000 is correct or not. They take it on good faith because that's what the seller's mortgage company said. So when the HOA says our lien is $4,000, the title company has no basis to question that one way or the other. Title companies do not adjudicate the HOA's payoff number. They have no basis to do it. So when the HOA turns in a number of $4,000, the title company says, okay, that's it. That's the number. They'll pay whatever's on the association's ledger. They often, it's not, I say this as a point of fact. If the seller says that number's not right, and they say that to the title company will often say something like this: go work it out with your HOA, take it up with them. And the seller might say, well, geez, my house has gone up in value more than I ever thought it would. I guess you're going to withhold it from my seller's proceeds. At the end of the day, that $4,000 payoff is off by $800. Am I going to turn around once this is all over and sue the association to get my $800 back? Rational people sometimes do that, and rational people often do not do that. So I'm not telling you or saying to anybody, embellish your payoffs, but there's a rational, fact-based reality that title companies do not adjudicate the payoffs. Title companies pay the association what it submits on its ledger. I'm not inviting embellishment, but it is how the system works. Title companies pay what lien holders submit. They do not adjudicate lien legitimacy. And sellers, when they pay more than they should have, or when sellers have more withheld from sellers' proceeds than they believe should have been withheld, their option is to sue after the fact or to sue before closing and say this is wrong. But in reality, sometimes that happens, sometimes it doesn't happen. And I'm not making any suggestions here. I'm just telling you this is how the system works. And under House Bill 2648, when the legislature says, this is what the statutory lien now includes, and they think that they can eliminate certain items from the closing, attorney's fees that have, unless they've been awarded by a court, when I'm kind of going back and forth here. Sellers would have to sue after closing. The way the title system works, whatever's on that ledger, if it's turned in, and we're not doing anything against the law here, but title companies do not adjudicate lien legitimacy. So what's going to end up happening is law firms that there is an attempt by these, there was an attempt at the legislature. I'm sorry, we're going back and forth. The sponsor of the legislation wanted to eliminate free collections, and it may be difficult to do contingency collections moving forward. We'll see how it all shakes out. All right, a couple of more here. House Bill 2119. An Arizona condominium or planned community this one says cannot charge a transfer fee when there is a conveyance of ownership between certain types of owners, such as a husband and wife or partner to partnership. This will be difficult in many circumstances. There are times when there are spouses with different last names, a trust beneficiary to a trustee. How would we know? There are different transactions like among commonly controlled entities. But this has always been the case under this statute. This doesn't apply to a fee or charge that is imposed by a document and that is payable to a nonprofit corporation such as an HOA for the sole purpose of supporting recreational activities within the association. So if we have a resale assessment, such as a reserve funding contribution or a capital contribution or some other resale assessment, an assessment due on sale, but it is used for the sole purpose of supporting recreational activities within the association, then this entire transfer fee statute that House Bill 2119 applies to wouldn't have applied in the first place. So there are some large associations that impose resale assessments, which is my term for it, of somewhat large amounts that could be, a full year's assessment, half a year assessment, or even a percentage where the where it's due on sale, kind of like a resale assessment, but we call it a transfer fee here because that's the way the statute defines it, but it's an assessment due on sale. But this entire statute wouldn't have applied in the first place to that type of resale assessment because it was used for the sole purpose of supporting recreational activities within the association. So this bill, House Bill 2119, may have had limited applicability in many associations that have that type of resale assessment or transfer fee, as it's called in the statute, might not have charged it in these transactions anyway, where it's an estate planning transfer or a transfer between commonly controlled entities or a partner to a partnership, spouses, essentially a estate planning transaction. So I don't think this one's going to have much impact because many documents would have exempted these transactions anyway. All right, let's talk about House Bill 2662. This one's big for professional management. The agenda must now be provided in advance of board meetings and membership meetings. We were always, within the last 15 to 20 years, we were providing notice of board meetings. And within the last several years, we've been providing a copy of the agenda at the meeting. Well, this one requires that the agenda must be provided in advance of board meetings and member meetings. But before we get too upset, I note this later in this slide. There's no consequence if we fail to follow the meeting we publish. So let me give you a generic agenda that we could publish and not get in any trouble. This is an agenda. Let's call the meeting to order. Let's confirm our quorum. Let's approve the previous meeting minutes. Let's deal with old business and new business, and let's adjourn the meeting. This is an agenda. If we were to put this out there for every meeting, I suspect that this would cover 100% of every meeting that we could ever have. Now, would some people say this is bogus? This is complete BS because you're not telling me what's really going to happen. Well, I think it does. You call the meeting to order. You confirm there's a quorum. We dealt with the minutes of the last meeting. There's always old business, there's new business, and we adjourn the meeting. This is an agenda. And if you tell people this is the way we're going to structure the meeting, this should work 100% of the time. Now, is this fair to people that the landscaping contract's going to come up? Well, it's going to come up under old business, or it's going to come up under new business. I think so. Is it really what they intended? I don't know. I mean, this is an agenda. Could it be better? Yes, of course it could be better. Of course they could have 20 things on it. I have seen and dealt with municipal agendas for city meetings, city council meetings, and they could have 50 items on there. And there could be a consent agenda with 75 items. If that's what they want, then the statute's going to have to be worded differently, because the way it's worded, this is an acceptable agenda. There is no penalty for a failure to follow the agenda. The statute creates no penalty for a failure to publish the agenda. But as long as the statutes are written the way they're written, they're asking for the agenda I just created. We do the agenda I created, and then next year they'll come back and say, you can't address anything that's not on the agenda. I mean, if that's the cat and mouse game that we want to play with the legislature, I suppose we can do that. And I'm not encouraging that in a sense. I mean, I'm just telling you what the statute requires and what we could do, but we could also have a 30-point agenda with everything on it and publish that in advance. And, then we avoid the cat and mouse game where next year they come back and say, you have to describe every item and you can't address anything that's not on the agenda. That would avoid coming back again next year. But I wouldn't be fair to the statute. It wouldn't be fair to my legal conscience if I told you that there's a penalty for failure to follow the agenda, or if I told you that there's a penalty for failure to publish the agenda. There isn't. And as long as there's no penalty for failure to follow the agenda, and as long as there's no penalty for failure to publish the agenda, this 6-point agenda is legal and adequate. You have to decide if it's a good idea for your community, because if you publish this 6-point agenda in advance of the meeting, the membership might pull a recall petition and say the boards should be removed for being disrespectful of the community, for having a 6-point agenda when the statute says you have to publish the agenda. And that's the risk. You could do my agenda, and then the membership could say, you're insulting our intelligence. The statute says you have to publish the agenda. You've insulted our intelligence. You should be removed. That's, you could say, well, there's right, and then there's out of office right. You could be corrected. You could be removed from office correct. I wouldn't want that for you necessarily. There's also an ADRE risk. You could use my agenda and you could be taken to the Department of Real Estate in front of an administrative law judge. An administrative law judge could say, well, you have this skeletal agenda, but it violates the spirit of the statute. I doubt that would be a winner because it is an agenda. It is an agenda. All right, a couple of quick ones that I included because they're interesting, not because they're going to change much about the day-to-day governance for professional community managers. House Bill 2720, this one addresses accessory dwelling units. These are little houses in rear yards, basically. Municipalities with a population of more than 75,000 must adopt ADU regulations by January 1, 2025. Here's language from the bill, House Bill 2720. This section does not prohibit restrictive covenants concerning ADUs entered into between private parties. So although municipalities must adopt ADU regulations by 1/1/25, any city over 75,000, that's pretty much every suburb in Maricopa County, Tucson and surrounding suburbs, and Prescott, Flagstaff, Yuma, basically all of our big cities must adopt these regulations. Basically, the legislature wants affordable housing, and their theory is that if people have ADUs in their rear yard, they should be able to rent them, and perhaps solve our homeless crisis by having more housing and more rental housing, and the people with big lots can rent these ADUs to tenants, and will expand available housing. So if you have a 1 acre horse property in the middle of Tempe, then you'll put an ADU in your backyard. Somebody will drive up to it down the main road, the main driveway of your house, and you'll rent it to a tenant, and that'll start to solve our housing crisis. But this sentence here says the covenants in that horse property community that say one dwelling per lot, capital L lot, one dwelling per capital L lot, that's enforceable. And House Bill 2720 does not usurp or take priority over that CC&R provision. That CC&R provision that says one dwelling per lot, per capital L lot, per horse property lot is still enforceable. So it's interesting in the sense that, to be complete, I want to let you know, we'll maybe see more rear yard accessory dwelling units, not just pool houses, but actually fully built ADUs, which are a new product type for some builders. And then House Bill 2721, this is being referred to as middle housing. Now, municipalities, again, with a population of more than 75,000, must adopt middle housing regulations. Like, what is middle housing? Well, legislature wants more townhouses and triplexes. And for those of you who have managed townhouses or triplexes, you know what this is. Well, they've defined townhouses as dwelling units that are constructed in a row of 2 or more attached units, where each dwelling unit shares at least one common wall with an adjacent unit, and that are accessed by separate outdoor entrances. For those of you who have managed townhouses, you know what this is. Of course, that's what a townhouse is. And then a triplex, 3 dwelling units on the same parcel or lot in attached, detached, or semi-detached arrangements designed for residential occupancy, but not more than 3 households living independently from each other. Okay, perfect. Well, they want more of this, and these municipalities have to adopt these regulations. And I guess the theory is that if the municipalities adopt these regulations, then the money will pour in, and home builders and developers will all of a sudden decide that this product type will be profitable. If the legislature forces municipalities and cities to adopt these regulations, that the housing type can be built and constructed profitably, and consumers, buyers, purchasers will want them. I'm not sure about that. I'm not saying it won't happen, but we'll see if this will occur. All right, Senate Bill 1432. And this is one where people have been troubled by the existence of racially restrictive covenants essentially CC&R provisions that say no Negroes, for example, and a remnant from our racist past. I've been doing this for 30 years, representing community associations. I may have seen one CC&R provision here in Arizona that said something like no Negroes in a community. And there's an effort nationwide to adopt a statutory framework that would allow one owner to remove a racially restrictive covenant from his or her property unilaterally. Well, this statutory framework was created so that all states could adopt the same framework called a Uniform Act. And so Arizona adopted this Uniform Act and said, under state law, here's how you do it. An owner can remove it from his or her property unilaterally. There's also a provision in Senate Bill 1432 for the association to do it, for a group of owners to do it. And what's a little weird about it is that racially restrictive covenant, as I've said it, no Negroes, for example, it's already illegal. It's completely unenforceable under federal and state law. But the idea is we'd remove it from the covenants by recording a new document that says, hey, we're removing it. But it's already removed, legally speaking, under federal and state law. But the document that says no Negroes is still recorded at the Maricopa County Recorder, what county you're in, the Pima County Recorder, Coconino County Recorder, La Paz County Recorder, whatever it is. The document is there in the land records. It can't be removed per se. We're recording a new document that says it's not applicable to my property, but it is inapplicable under federal and state law. So, as I said, there are very few in Arizona that I'm aware of. If there are more than a handful, I'd be shocked. So this effort is underway. There may be some lawyers who are willing to help pro bono. And if somebody were to ask me to help pro bono, I absolutely would. And so we'll see where this goes. As I'm standing in front of you right now, I'm not even sure where to go find one. If we were to hunt for them, as I said, I've probably only seen one, if I can even say that with any certainty. House Bill 2698, this has to do with developer control, planned communities only. Developer control has to do with the initial period of development where the developer controls the board of directors, that appoints the board. The statute says each declaration, CC&Rs, that provides for a period of developer control must also provide for a date of or method for calculating the date of the termination of developer control. No problem. Most of them do. In fact, all of them do. Never seen one that didn't. And then for every community, without regard to whether the community documents provide for the termination, which they do, it's a little kind of a weird statement. Developer control terminates not later than the date on which the second to last lot in the community is conveyed to a buyer. All right, so we have statutory certainty here. We've always had statutory certainty in a condominium, so now we have it in planned communities. For some, this may seem a little late in the process. In a condominium, it's at 75% of the units sold to real human buyers or real non-developer buyers. This may seem a little late in the process for some, but it's now we have certainty about when it is. So that's good, I guess. Of course, at any point, the developer could relinquish control voluntarily. This is now the new rule. And then after termination, and while the developer still owns one or more lots, the association has to provide at least the same level of maintenance of common areas that the developer provided, and the association cannot stand in the way of the developer's ability to develop, construct, and sell its lots, and not interfere with access to and use of common areas by the developer in the same manner as other members. So essentially, the developer has an easement to continue to develop the community, so that's no problem. But provide at least the same level of maintenance of the common areas and don't get in the way of development. So to me, these are pretty obvious things and not really a problem that we were seeing. I've never heard of any problem with any of this. The developer, the generic developer, mush all developers together and say, well, the generic all developers, we're not really having a problem controlling and turning over associations and planned communities and maintaining common areas at the same level a developer did. Real testament to professional management. Developers hire good professional management, maintain the common areas. And I've never heard any stories of developers not being able to have access to develop and sell the association and use the common areas to finish the project. This is in some ways kind of a solution in search of a problem. So this is all generic stuff and confirmation of the way things have always been and can continue to be. So this is all good stuff. All right, Senate Bill 1016. Seems like every year the legislature decides there's a big problem with flags in planned communities and condominiums, when in fact there isn't a big problem with flags. People want to fly flags every once in a while. And whenever an association decides that it wants to say something about flags, the person on the receiving end of that statement about flags goes to their legislator. And the legislator says there ought to be a law. So we end up with legislation on flags just about every year. Well, this year we got this. Owners can have 2 wall-mounted flagpole holders. That's this year's flag legislation. So you want 2 flagpole, 2 wall-mounted flagpole holders, you can have. That's this year's flag legislation. So that's reason to celebrate if you want 2 flags. All right, let's talk about last year's statute, authority over public roadways. This was merged into Arizona Revised Statutes, section 331818. Forget the bill number, but once a bill becomes a law, the bill numbers become irrelevant. So here's what it says. After the period of declarant control, for any planned community for which the declaration CC&Rs were recorded before January 1, 2015, and for that community that regulates any roadway for which the ownership of the roadway has been dedicated to or is otherwise held by a governmental entity, those regulations continue in effect until either of the following occurs. Not later than June 30th, 2025. That's 11 months away. 11 months plus a few days. The planned community must call a meeting of the membership on the question of whether to continue to regulate public roadways. Do we have to vote? So the vote is, do we want to continue to regulate public roadways? And that's the question. And what we have struggled with as a planned community of associations across the state, where the streets and the roadways have been dedicated or are otherwise held by a governmental entity, what we have struggled with is, what does it mean to regulate the roadway? What does it mean to regulate the roadway? Now, for some people, this is a simple question. Do we enforce parking restrictions on the public roadway? Because after all, that's all that anybody talks about. Do we care about parking of vehicles on the public roadway? That's all anybody talks about. Do we care about RV parking, boat parking? Do we care about basketball hoops and cul-de-sacs of a public street? What do we mean by regulate a roadway? What did the legislature mean by regulate the roadway that's been dedicated to a governmental entity? There are lots of answers to this question. It's probably all of the above. Does it regulate a roadway to enforce a private covenant on the private government, to the governmental roadway, regulate a roadway? The owners, when they agreed to the CC&Rs, made a promise. I won't park my car on the roadway. I won't park my RV on the roadway. I won't park my boat on the roadway. Does that regulate the roadway? Do the owners care about that or not? So the legislature said, you can keep your roadway regulation, but you have to vote on it before June 30th, 2025. If the number of owners voting at the meeting is sufficient to constitute a quorum, and a majority of that number votes to continue regulating public roadways, the planned community retains its authority to regulate those public roadways. And then we'll record a notice at the county recorder, confirming that the planned community continues to regulate the public roadways. That's what B1 says. And if we don't do the vote, or if the vote fails, then we lose our roadway regulation. It doesn't apply to one-way streets or privately owned roadways. So the challenge here is also includes situations where some municipalities have entered into contractual agreements with associations to maintain public roadways. For example, I've had clients where the developer and the city get together and say, well, there's a median in the public roadway, but the developer wants enhanced landscape maintenance. So the developer and the city get together and say, well, you want enhanced landscape maintenance in the median above the minimum city standard. We'll enter into an agreement for that, but the HOA will have to maintain it that way in perpetuity, forever. Does that regulate the roadway? I don't know. But if the association wants to maintain that regulation of the roadway, or if there's a right-of-way agreement where the association maintains landscaping of some other type, we may need to vote to affirm that before June 30th. Now, you might say, well, Scott, maybe that sort of makes sense to me, but isn't it the city's job to come to us and say, hey, we need you to vote before June 30th to affirm these agreements? Maybe. But we need to be thinking about this in a comprehensive way. And for many of us, and I'm saying that globally within our industry here, we've been thinking about this as vehicles and parking. and the word vehicle does not ever appear in the statute, and the word parking does not appear in the statute. We've got to think a little more broadly about this. But there's time between now and June 30th to put a vote on a ballot for the annual meeting of the association between now and June 30th of 2025. We have time. We can do this at the annual meeting between now and June 30th, 2025. We haven't blown it. We don't have to do a special vote. We don't have to have a special membership meeting, as long as we put this on the agenda for the membership meeting between now and June 30th, 2025. And even if the board doesn't want to regulate the roadways, let's put it in front of the membership. Let's let the membership decide. It's not that problematic, really. All right, let's talk about the Federal Corporate Transparency Act. The Federal Corporate Transparency Act has a December 31st, 2024 deadline. I'm hitting you with a lot of different deadlines here. This is a federal statute that says, due to federal money laundering concerns and Russia's invasion of Ukraine, every corporate entity in America has to register 4 pieces of information with the federal government before December 31st. Name, residential address, driver's license number, and an image of the driver's license before December 31st, 2024. There's a website on the Amazon scale. It's Amazon Good. It's extremely easy. Go to this website and provide those 4 data points, and what you get back is a 12-digit number. That 12-digit number is affiliated with the association. Let's call the association Greenacre, or in Seinfeld terms, Del Boca Vista. And the association, under the vernacular, the vocabulary of the Corporate Transparency Act, the association is the reporting company. The board president, the senior officer, is the beneficial owner. The 12-digit number is affiliated with the reporting company. Once the 12-digit FinCEN ID is affiliated with the reporting company, then the matter is completed and the process is done. So the beneficial owner gets the FinCEN ID, the 12-digit number. We affiliate with the association. That's done. So there's a lot of confusion about this. People have made it much more complicated than it needs to be. I've done it myself. I have a 12-digit FinCEN ID, have an LLC that I manage for my parents, and it's extremely simple, extremely easy. As I said at the beginning, there's this idea that there's a court case in Alabama that said that the whole process is unconstitutional. That's true, but the judge did not enter a nationwide injunction. It's unconstitutional for a series of plaintiffs in that case only, and it remains a legal obligation for the rest of us, and there's no time for Congress to fix it or to create an additional exemption between now and the end of the year. This is the law. It needs to be complied with, and we need to be ready for it in the next 5.5 months, 4.5 months. All right, there's some additional resources. I will PDF this PowerPoint. I will have a more detailed explanation PDF in the next day or two. Info@carpenter.law is the place to get it all. Nick Eicher, my law partner, will be available as well. I'm at Scott@carpenter.law. As you'll notice, there's a new domain called .law. There's no .com. Don't send anything to a .com domain name. This is how it works now. This is carpenter.law. We have time for a few questions. I see that there's a few in the Q&A. How does this only apply to multi-floor condos? I may have misspoke. It is adjacent condos, but I'm concerned about noise really being from hard surface flooring. Dave? On the transfer fees, for an association with no recreational facilities that charges a reserve contribution, can they still charge the fee? The prohibition on transfer fees statute has a number of exemptions. If it's a resale assessment where the transfer fee goes to the bottom line of the association, there are a number of exemptions in the statute. I may need to talk to you about it offline, but a transfer fee that compensates the management company for the work of facilitating a transaction is not prohibited by that statute. The resale disclosure fee, of course, is always permissible. The $400, nobody's concerned about that. But a transfer fee that charges money that goes to the association's bottom line, like an assessment, that's what the statute is about, Dave. And so I'm concerned that if the association is charging a fee at sale that goes directly to the association's bottom line, there's a statute that addresses that, and we need to find an exemption. Does the agenda statute also require agendas for the committee meetings? No, just the board and membership meetings. Good question, Anne Marie. If a board member wanted to discuss an item that was not put on the agenda, could that be brought up in the open session of the meeting? Would that be another way to address items not on the agenda? Actually, it's a good question. I'm not worried at all about it because there's no requirement that we only address things on the agenda. So, not worried about it at all. If a condo revises its CC&Rs, all right. Question about 2698. If a condo revises its CC&Rs, yes, if an association is revising its CC&Rs, if a condo is revising its CC&Rs, all of the stuff about developer control can be omitted from newly revised CC&Rs. Absolutely. As far as, I mean, in answering some of these questions, I'm going to go back and remind myself what I said. Authority over public roadways. Does this include dumpsters or storage bins on the public street? If the city has placed dumpsters or storage bins on the public street, or perhaps the association has placed them on the public street, or maybe the association has put a dumpster or a storage bin on the public street, question is, does this statute include dumpsters or storage bins on the public street? If the association's asserting that it can put a dumpster or storage bin on the public street, I feel like that's kind of like asserting authority over the public roadway. If the city has allowed it, then I wouldn't worry about it too much. If you have the city's permission to put a dumpster or storage bin on the public street, I wouldn't worry about doing the vote. But if the city has not permitted it, I don't know, it's kind of a weird one. I don't know how to answer that, quite frankly. If the city has given you permission to put a dumpster or storage bin on the public street, I wouldn't worry about the vote too much. I would just worry about them revoking the permission. Question, is it the vote just at the meeting or is it per the CCNRs? It's a special vote requirement here in subparagraph 1. If the number of votes at the meeting is sufficient to constitute a quorum of the membership and a majority of that number of votes to continue regulating public roadways. So we have a special majority of those that show up so long as it's a quorum. It's a special requirement. So it's per the governing documents, I'd say, not necessarily per the CCNRs. Anonymous attendee, for the Transparency Act, is it for board members? Under the Corporate Transparency Act, the debate has been whether it has to be done by all directors or whether it can be the senior officer. And there's a difference of opinion here. Some conservative East Coast lawyers have said it has to be every director. And there's a reason to understand that perspective, that all directors should register or sign up or be the beneficial owner because of collective decision making. Another school of thought by more assertive or aggressive West Coasters like me is, if the senior officer, president, vice president, somebody like that, signs up and says, I'm the senior officer, and you register, then essentially that association, Green Acre, Del Boca Vista, whatever you want to call it, has taken responsibility, and that corporate entity is compliant. When does the federal government going to have the resources to look beyond that entity where someone has taken responsibility, obtained the 12-digit number, affiliated that responsibility? There's way too many corporate entities. There will be way too many that have not complied. The government doesn't have the resources or the time to say, wait a minute, Green Acre has 5 directors according to the Corporation Commission, and only Bob, the president, signed up. What about these other 4 people? Can you imagine the resources and the time necessary to look beyond that? So for now, I don't think it's too dangerous for the senior officer to take responsibility and for those other 4 people to not participate. But if everybody wants to do it, they can. Can condos still keep their specific acoustical underlayment requirements for hard surface flooring? Or are we going to have to remove that? I'd keep it. I'd keep it, and I'd keep it under the theory that you are working to reduce or eliminate the, we go back to the beginning here, that your goal is to, your goal is to eliminate or minimize the potential disturbance. And so whatever your acoustical underlayment requirements for hard surface flooring are, you're choosing to eliminate and minimize the potential disturbance. Michelle, I'd keep it. Kelly says, submit a driver's license for Corporate Transparency Act. Is this just the board president's license or other board members? If under the Corporate Transparency Act, you're simply going to use the senior officer, it would just be the president. And it wouldn't be the president giving it to anybody else. The president would go to that website right here and obtain his or her own 12-digit number for the FinCEN ID, and then hand that 12-digit number over to the management company or whoever is going to affiliate that 12-digit number with the reporting company, which is the association. This can all be done anonymously. No director has to give their driver's license or their passport to someone else. You go to that website and you do your own thing and get your own 12-digit number. It's not that you don't, when I did it, I just sat in my office, typed in my name, a residential address. I used my passport number, and I took a picture of my passport. I uploaded it. I got my 12-digit number, and I used that to affiliate with the LLC that I was registering. Someone said, thanks for talking about horse property. Okay, is there a requirement to follow open meeting law? Absolutely, there always is. But our open meeting law is not the same as the government's open meeting law. We have a separate open meeting law in the HOA world. What name goes on the Corporate Transparency Act registration? Well, I have my own 12-digit number. I affiliate my 12-digit number with Del Boca Vista because I'm on the board of Del Boca Vista. I'm kidding, of course, but and then Del Boca Vista is registered because Del Boca Vista has an EIN number. It was formed in Arizona, let's assume. And then Del Boca Vista has a beneficial owner, which is me, and my 12-digit number, and then the registration is complete. Here's a question. What about underlayment requirements that are called out in the CC&Rs for acoustical underlayment? Are these no longer acceptable? I would say they're applicable. I would say they're applicable because we're reducing and eliminating the, what's the word I used? Because wherever word I used is in the statute. Let's go back to that one more time. To get this right. Eliminate or minimize the potential disturbance. If those acoustical underlayment requirements in the CC&Rs eliminate or minimize the potential disturbance, they're good. Hope the audio is okay. If we have rules regarding trash and recycle cans out in front of the home, is that authority over roadways? I'd hope not, but a vote can't hurt. When the board changes, does the next president have to sign up for the Transparency Act? Yes, we have 30 days to change the registration when the board changes under the Corporate Transparency Act. Then Kelly, that's the answer to your question. We have 30 days when there's a change. We have 30 days to change the registration. All right, thank you all. I went a little over, but I'm glad to answer your questions, and hopefully you can join me next month. I forget what the topic is, but we'll do this again next month. And thank you for joining me. And like I said, we'll send you these resources if you send a request to info@carpenter.law. Thank you. Have a great day.